Welcome to DakshaLegal online seminar. Today's topic is instruments not duly stamped. Though the speaker needs no introduction, since DakshaLegal now is an all India knowledge sharing platform, let me say a few words about the speaker. Justice A.N. Venugopala Gowda was enrolled as an advocate on the rolls of the Karnataka State Bar Council on 26th October 1979. He practiced at trial courts, appellate courts, tribunals, and the High Court of Karnataka. He worked as the principal High Court government advocate and special counsel for the Common Entrance Test Cell and CAC Cell. He was in the panels of advocates of Karnataka Public Service Commission, Indian Railways, Bangalore Development Authority, and various other statutory authorities and bodies. He was appointed as additional judge of the Karnataka High Court on 4th July 2007 and as a permanent judge on 17th April 2009. He retired on 15th June 2017 on attaining the age of superannuation. As a judge of the Karnataka High Court, he decided about 53,000 cases. Post-retirement, Justice Venugopala Gowda sir is conducting arbitrations. He is now designated as a senior advocate by the Supreme Court of India with effect from 6th September 2018. I extend a warm welcome to Justice Kodandaram, sitting judge of the Andhra Pradesh and Telangana High Court, under Mr. Tallur, former Secretary Public Works Department. Kindly note that this seminar is also relayed on DakshaLegal Facebook page and will be posted on YouTube later. Over to you, sir. Justice Venugopala Gowda, sir.
Good evening, Basuraj. Good evening to all viewers as well as listeners. I do not know how much time Mr. Basuraj is giving me.
Sir, till 10 o'clock. 10:30.
All right. Let us see. Because I should not be boring people by taking longer time. Now, today's topic falls within Chapter 4 of the Karnataka Stamp Act 1957, which is analogous to the provisions contained in the Indian Stamp Act or other state enactments are concerned. I have seen some of the state enactments vis-a-vis the Indian Stamp Act. They have almost provisions which are paramateria with each other, except one or two sections. Now, all of you know that Stamp Act is a fiscal measure enacted by the competent legislatures to serve the revenue of the state, and its object, according to me, is well served by Section 33 thereof, or 33 of Karnataka Stamp Act 1957. Fundamentally, 33 pertains to examination and impounding of the document or instrument. Wherever I refer to as document, it can be instrument or vice versa. Now, this section confers power on all those persons who have, either with the consent of the parties or with the authority of law, the power to record evidence. That is the basic element, which I'll take you to the relevant provision little later. Now, this stamp duty is nothing but a kind of taxation by the government on certain categories of documents enlisted in the schedule thereof. Or you can find in the articles under Schedule 1, wherein different kinds of deeds or matters relating to transactions have been enumerated. Now, to start with, I would say we will have to look into what is contained in Section 2(1)J, which is the definition of instrument, and that has to be read along with Section 3, which is the charging section of the Act. Once we read that, then we will have to consider the definition of chargeable under 2(1)B From there, we would be moving on to the definition contained in 2(1)(f), which is with regard to executed and execution, which has to be read along with Section 31 of the Act. From there, we can move to Section 2(1)(e), which defines duly stamped, and this has to be considered vis-a-vis Sections 33 and 34 of the Act. Now, the power to impound an insufficiently stamped document or an instrument which has not been duly stamped is conferred under Section 33. Now, I'll take the listeners to these provisions a little later, but prior to that, to start with, the principles relating to charging stamp duty, according to the Supreme Court, can be seen in a judgment with the title S.N. Mathur versus Board of Revenue. I'm sharing it on the screen itself. The 2009 13 SEC 301, S.N. Mathur versus Board of Revenue. Citation is 2009 13 SEC 301. At para 12, Honorable Supreme Court has enlisted the principles relating to charging of stamp duty, and they read as follows. 1. The object of Stamp Act is generation of revenue. Kindly bear this in mind. The object of Stamp Act is generation of revenue. It is therefore a fiscal enactment and has to be interpreted accordingly. Meaning thereby, there is no equities here. It has to be literally understood as it is. Second one is, stamp duty is levied with reference to the instrument and not in regard to the transaction, unless otherwise specifically provided in the Act. Now, it is always the instrument that is considered, instrument vis-a-vis the writings therein, and not the whatever is the head note or the title or etc. etc. Then third one is, stamp duty is determined with reference to the substance of the transaction as embodied in the instrument and not with reference to the title, caption or nomenclature of the instrument. Kindly see, I believe all the listeners are either law graduates or practicing lawyers or persons dealing in law. That's why I need not have to go into the basics. With an understanding that all are practitioners of law, are well versed with law, I'm just going ahead. Then fourth one is, for classification of an instrument, that is, to determine whether an instrument comes within a particular description in an article in the schedule to the Act, the instrument should be read and construed as a whole, not in parts, but should be construed as a whole. Then the last one, last principle according to Supreme Court is, where an instrument falls under two or more descriptions in the schedule to the Act, the instrument shall be chargeable with only one duty, that is, the highest of the duties applicable to the different description. But where an instrument relates to several distinct matters, it shall be chargeable with aggregate amount of duties to which separate instruments would be chargeable. In this case, a trust deed was executed. The basic facts of the case was, trust deed was executed. Para 3 of the para 8 shows, para 8 of the judgment shows that the trustees divested themselves of the title to the property, which they gave it to the trust, and they, in order to avoid stamp duty, they termed it as a trust deed, though it was in effect a settlement deed. The authority referred it for adjudication. The adjudicating authority found it to be a settlement deed, directed the payment of difference of duty and penalty.
One small announcement, sir.
Yes, sir.
So we are full now. We have reached 100. Many are asking to join. It's not possible. Kindly join our Facebook group DakshaLegal, where it is directly relayed as of now. Thank you very much.
Thank you. Thank you. Please, we are sorry that we will not be able to accommodate here. Basuraj is taking care of the interests of all. He has accommodated elsewhere. Okay. Then here, though it was not a trust deed, it was titled as trust deed, and stamp duty was paid because it costed less. Later on, when the adjudicating authority found that it is not a trust deed, but is in effect it is a settlement deed, difference of duty was directed to be paid. That was challenged in the High Court until the Supreme Court, and ultimately the Supreme Court, having found the instrument to be a trust deed, directed that the difference of duty and the penalty be paid. Now, keeping this in mind, now let us see what the relevant provisions of the Act are, because we will be dealing with Chapter 4 of Karnataka Act 1957, Karnataka, that is Stamp Act 1957, that starts from Section 33 to 46B. It encompasses, Chapter 4 encompasses Sections 33 to 46B. Oh, 33. No, you please go to Section 21J. Section 21J. Now let me first draw your attention to Section 21J. It can be accessed from the screen itself. Instrument means it includes every instrument. Instrument includes, it is an inclusive definition, includes every document and record created or maintained in or by an electronic storage and retrieval device or media by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. So this definition is very inclusive. It is quite encompassing. It wherever any document which is either in writing or in electronic form confers any right or liability, then such document is included in the definition of instrument. From there, we can move to Section 21B. 21B. Definition of chargeable. Now I'll take you therefrom to Section 3. The charging section for the enactment. Instrument chargeable with a duty. I'm not reading the entire section. Wherever it is necessary, I'll read it. I'm just drawing your attention to the relevant provisions so that we can move ahead with that. Then you can find a definition under 21F. It's an interesting definition because this has a relevance to Section 31 and 32. Just keep that in mind. 21F is executed and execution. It is one is past and the other one is present. Executed and execution used with reference to instruments mean signed and signature. Document signed and signature, which is already signed is executed, which is being signed is signature. Then comes to 21E, an important definition with which we will have to deal with. 21E is duly stamped. Now, duly stamped is, as applied to an instrument, means the instrument bears the impressed stamp of not less than the proper amount of that stamp duty has been impressed in accordance with law for the time being in force in the territory of state of Karnataka. Now, according to my understanding, it can be put into three categories. One is stamp must be of a proper amount vis-a-vis the transaction involved in the instrument. One is stamp must be of proper amount. 2 should bear proper description of the stamp, and 3 stamp must have been affixed and used according to the law in force in the state of Karnataka. So these 3 elements get encompassed in this document, what is styled as duly stamped. From there, let me take you to section 33 of the Act. 31 and 32 I'll deal with at the end. That is the gateway or window for the person who is liable to pay the tax duty or the penalty, as the case may be. I'll deal with it at the end. Now, this chapter 4 is instruments not duly stamped. There, the definition is duly stamped. Here, instruments not duly stamped. Now, kindly see here, subsection 1, every person having by law or consent of parties. Now, this is where many a times these arbitrations fall in. I had an occasion to deal with a matter in the Harvard bench where a contention was urged by Mr. F.E. Patil, learned advocate, that arbitrator being not a person appointed by law, but only by consent of the parties. There it was only merely an agreement of the parties, arbitration had commenced. That's why the stamp duty is not liable to be payable on the award. That is what the contention urged, which I overruled it. Then here, with reference to having by law or consent of parties authority to receive evidence. So if parties consent a person, even a private person, to receive evidence, then it falls within the meaning of authority of law. Then every person having by law or consent of parties authority to receive evidence, that is important, and every person in charge of public office. See, there is 2 categories. One is a person authorized by law or consent of parties to receive evidence. The second category is every person in charge of a public office. Then, except an officer of police. As far as police is concerned, no. Before whom any instrument is produced, that is after the exception. Before whom any instrument chargeable in his opinion with duty is produced, not being made use of, is produced or comes in the performance of his functions. Now, production can be before the court, or as far as public authorities are concerned, in discharge of their duties, comes in the performance of his functions, shall, if it appears to him, that is either to the court or to the public officer or the person authorized to receive evidence, if it appears to him that such instrument is not duly stamped, impound the same. Now, impound, as you all know, is to keep it in safe custody, to be dealt with in accordance with law. Then subsection 2 is concerned for that purpose, that is for the purpose of examination and follow-up action. For that purpose, every person shall examine every instrument. This is a statutory mandate on the persons who are authorized by law or by consent of the parties to receive evidence, or public authorities other than the police, shall examine every instrument so chargeable and so produced or coming before him, in order to, for what purpose? In order to ascertain whether it is stamped with a stamp of the value and description required by law in force in state of Karnataka, when such instrument was executed or first executed, with reference to the date of execution and not what is to be done in either in the present or in future. Then, provided there is a proviso there, nothing herein contained shall be deemed to require any magistrate or a judge of a criminal court to examine or impound. There is a sort of relief given before the magistrate court or before a criminal court, if that is in the opinion of here, if he does not think fit to do so, that is the magistrate or the criminal court does not think fit to do so, any instrument coming before him in the course of any proceeding other than so and so, that is provisions under chapter 12, under chapter 26 of CRPC. In respect of those 2, there is an obligation. In respect of the others, some kind of a relaxation is given as far as the magistrate or a judge of a criminal court is concerned in the matter of examination and impounding is concerned. Then subsection 2 is concerned. This applies to the High Court only and not to the other public office authorities or the trial courts are concerned. There is a power to delegate. In case of a judge of the High Court, the duty of examining and impounding any instrument under this section may be delegated to such officer as the court appoints in this behalf. The purport of this clause B has been explained in great detail by the Supreme Court in a judgment reported at 2017 4 SCC 498, which I'll refer to a little later. In the case, that is in the case of Black Pearls Hotels. There, the High Court had delegated the authority to High Court of Karnataka had delegated the authority to the registrar judicial for the purpose of examining and taking further action. That was found fault with. The appeal was allowed. Matter was remanded back to the High Court for consideration in accordance with the observations made therein. Then the rest of the provisions appearing therein may not be very relevant. I'll take you to now to section 33. Section 34. Section 34, which has a direct bearing or which is nothing but a sister provision for 33 is concerned. 34 says, instruments not duly stamped, inadmissible in evidence. This is where all the problem comes. Now, why for we draw instruments? It is for the purpose of having a record. It is for the purpose of proving certain thing before a court of law or before public authority in case it becomes necessary. Now, if such a document is inadmissible in law, then everything is lost. So, to secure our rights, in case of necessity before a public authority or an officer or a person authorized by law or person authorized to record evidence, then every document should be properly stamped and executed. It is only such document which can be made use of as evidence. This is what is contemplated in section 34. Now you saw from reading of section 33 that it fundamentally serves the purpose of the whole act itself. Because every person authorized by law or by consent of parties or public authorities are bound to examine every document for the purpose of finding out whether it has suffered proper stamp duty or not. It is only when they are satisfied that it has been properly drawn, then that document can be looked into, acted upon, and the rights or liabilities of the parties regulated in terms of law. So 33, according to me, is the heart and core of the enactment. It serves the purpose of the government. It mandates either the person authorized by law or person consented to by the parties to record evidence or public authorities to safeguard the revenue of the state. The state has trusted all these three categories of people, that is persons authorized by law or persons who are before whom consent has been given for recording of evidence. Then the third one is public authorities, to see to it that there is no evasion of stamp duty. They being public authorities, falling within the definition of public authorities as far as IPC is concerned, they are all required to safeguard the interest of revenue of the state. That's why they have been entrusted with this job to secure that no revenue is evaded in any form. As it is, the revenue loss as far as stamp duties is concerned is less compared to the sales tax or other fiscal enactments are concerned. Then coming to 34, instruments not duly stamped are inadmissible in evidence, etc. It doesn't stop there. Then no instrument, it starts with a negative. No instrument chargeable with duty shall be admitted in evidence for any purpose. Please mark this word, for any purpose. Many a times for collateral purpose and all is being said, that is not permissible. Even for collateral purpose also, the document should have definitely been sufficiently stamped or duly stamped. Otherwise, it is not admissible for any purpose. I'll take you to one or two judgments of the Supreme Court on that aspect of the matter. Then no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties to receive evidence, or shall be acted upon, registered or authenticated by any such person or by public officer, unless such instrument is duly stamped. Now it starts with a negative. It says that such a document, upon examination, if it is found to be not sufficiently stamped or not duly stamped, shall not be received in evidence unless the deficiency is made good in accordance with the provisions of the Act. It is not only paying the difference of stamp duty or making good the required amount of stamp duty, it may draw in certain occasions penalty which goes up to 10 times, which I will be taking you in the other provisions of the enactment are concerned. Then 34, it states it has a proviso. Proviso A contemplates a penalty of 10 times on, that is what, though it is a long proviso, the ultimate purpose is that a sum equal to 10 times of such duty or portion thereof can be levied, is what is contemplated in A. B, where a contract or agreement of any kind is effected by the correspondence existing between two or more letters, and any one of such letters bear the proper stamp, the contract or agreement shall be deemed to be duly stamped. Both need not be stamped. If it is one chain of events, if one document, one letter has been duly stamped, that will hold good. That is the relief that has been given to the citizen is concerned. Then C, nothing herein, that is nothing herein contained, shall prevent the admission of any instrument in evidence in a proceeding in criminal court other than the proceedings under Chapter 12 or Chapter 26 of CRPC. This you can read it along with the proviso which I read out under 33(2)(a) is concerned. Then 32(d) is important. Here it says, nothing herein contained shall prevent the admission of any instrument in any court when such instrument has been duly executed by or on behalf of the government. For government documents, these provisions have no application. So that's why there is an exemption. Then R, where the alternative is R, where it bears the certificate of the Deputy Commissioner as provided by Section 32. I have not read out to you 32 so far. I'll come to it later. As provided by Section 32, R or R again, any other provision of this Act, and such certificate has not been revised in excess of the powers conferred under Chapter 6 of the Act. Chapter 6 is the powers given to the Chief Controlling Authority if it has been revised therein. So these things, there is an exemption granted. 32 is one such provision. Then the other one is that of the order passed by the Chief Revenue Officer is concerned. This 32D, according to me, has to be read along with 32(3). 32(3), which I will take you a little later. Then we'll be going to 35. 35 is a kind of relief when somebody is not vigilant before a court of law. Somebody is sleeping over or remains absent, then how their claims suffer can be seen from this provision. Admission of instrument were not to be questioned. It can be a temporary relief only. It cannot be permanent relief. There is a checkmate there. When an instrument has been admitted in evidence, such admission shall not, if it is already admitted, such admission shall not, except as provided in Section 58. 58, when you go, then it comes to appeal or revision, so motu power being given to the appellate court or the court of first instance, and an application being filed by the Deputy Commissioner before that court for taking necessary action because of the revenue involved for the state. Section 58, be called in question at any stage of the same suit. Suppose it has not been objected, marked as an exhibit, then it shall not be questioned at any stage of the same suit or proceeding on the ground that the instrument has not been duly stamped. This provision has been interpreted by the Supreme Court in number of judgments. Once it is duly admitted in evidence, such admission cannot be reopened in the same suit at a later stage of the proceedings, and parties will have to bear the consequences. And what can follow is as provided in Section 58 of the Act, and nothing for the present, that is in the present suit or other proceedings as the case may be. Then coming to 36, we are not really concerned. It is admission of improperly stamped instruments. It may not arise at all in number of cases. It has no such. There is not much case law on this aspect of the matter, because that proceeding is probably is in disuse or not being put to use anywhere by any authorities are concerned. 37 has to be read in the context of impounding under Section 33. Here it says, when the person impounding an instrument under Section 33, that is, person authorized by law or person who records evidence by consent of the parties or public officer. When the person impounding an instrument under Section 33 has by law or consent of parties authority to receive evidence and admits such instrument in evidence upon payment of a duty, upon payment of a penalty as provided by Section 34. Section 34 enables the court or the authority, as the case may be, to impose 10 times of the penalty. Suppose it is paid, then the document can be admitted in evidence. 34, again, once the document is admitted in evidence, a copy thereof, attested copy thereof, and the duty and penalty collected has to be transmitted to the Deputy Commissioner for appropriate action in exercise of these powers, which I will be referring to later. Such a document is referred to here. Upon payment of penalty as provided by Section 34 or of duty as provided by Section 36, he shall send to the Deputy Commissioner an authenticated copy of the instrument together with a certificate in writing stating that the amount of duty and penalty levied in respect thereof, and shall send such amount to the Deputy Commissioner or to such person as he may appoint in this behalf. That is, person who impounded the document, and before that authority, the person who wants to rely upon the document immediately and get relief tenders the penalty, which cannot be less than 10 times. There is no discretion as far as the impounding authority is concerned. 10 times penalty has to be levied. Once that is levied, the instrument can be immediately acted upon also, and thereafter the authenticated copy of the impounded instrument together with the certificate in writing of the together with certificate stating the amount of duty and penalty levied should be informed to the Deputy Commissioner or sent to the Deputy Commissioner for further action is concerned. That I will deal with later. Then subsection 2, in every other case, meaning thereby what is not covered in 33(1), in every other case, the person so impounding an instrument shall send it in original to the Deputy Commissioner. Suppose the document is impounded, person is not ready to pay 10 times of the duty and penalty, then in that event, it is not the authenticated copy that has to be sent. The original itself has to be sent to the Deputy Commissioner for further action. That is what is contemplated under Section 37(2). From there, we move on to Section 38. Section 38. Deputy Commissioner's power to refund penalty paid under Subsection 1 of Section 37. I read out earlier 37(1) and 37(2). Now, the powers of Deputy Commissioner as far as 37(1) is concerned. When a copy of an instrument when a copy of an instrument is sent to the Deputy Commissioner under Subsection 1 of Section 37, he may, if he thinks fit, refund any portion of the penalty in excess of ₹5 which has been paid in respect of such instrument. As far as the impounding authority, there is no discretion. Whereas as far as the Deputy Commissioner is concerned, there is an amount of discretion, and that he can exercise when he receives the authenticated copy with penalty and in excess of power under section 37(1) is concerned. Whereas under subsection 2, when such an instrument has been impounded only because it has been written in contravention of section 13 and 14, may refund whole penalty so paid. If it is an impounding in excess of power under section 13 and 14, the whole penalty can be refunded also. That is the power that has been given to the Deputy Commissioner. Then 39, Deputy Commissioner's power to stamp instruments impounded. Now, this does not take in 37(1). 39 is concerned, does not deal with 37(1). It deals with 37(2). When the Deputy Commissioner impounds any instrument under section 33, Deputy Commissioner can also do it. Any public authority can also do it. That's why section 33 impounding is there. Other than section 33, there is no provision for impounding under the Stamp Act. Whereas the court can impound the document under in excess of its powers under Order 13, Rule 8 CPC is concerned. When the Deputy Commissioner impounds any instrument under section 33 or receives instrument sent to him under subsection 2 of section 37, that is the original instrument, not being an instrument chargeable with duty of not exceeding 15 naya paise only or mortgage or so and so, he may adopt the following procedure. That is, when he gets the document under section 33 or under 37(2), then he has to follow the procedure there. A, if he is of the opinion that such instrument is duly stamped or is not chargeable with duty, that is, in his opinion, he shall certify an endorsement by endorsement thereon that it is duly stamped or that it's not so chargeable as the case may be. Because the power of adjudication is given under the Act to the Deputy Commissioner if he, on examination or adjudication as the case may be, if he certifies that the document has been properly drawn and has suffered sufficient stamp duty, then he shall endorse that it is not so chargeable. Then B, if he is of the opinion that such instrument is chargeable with duty and is not stamped, that is contrary to what was said in 39A, he shall require the payment of proper duty or the amount required to make the same, together with penalty of 5 rupees, or if he thinks fit, an amount not exceeding 10 times the amount of proper duty or the sufficient or deficient portion thereof, whether such amount exceeds or falls short of rupees 5. Here, again, 10 times he is also empowered to levy it, but he has a lot of discretion. That is what the courts have explained. I'll refer to those judgments a little later. Then we'll move to subsection 2 therein. The proviso we need not have to bother ourselves. Subject to any orders made under chapter 4. 6. 39.2. Chapter 6. 39.2. Section 39.2. So subject to the provisions made under chapter 6. Every certificate under clause A of subsection 1 shall, for the purpose of this act, be conclusive evidence of matters stated therein. That is, with regard to the endorsement of sufficiently stamped, that will be sufficient evidence or conclusive evidence of the matter stated therein. Then subsection 3 is related to what is stated in subsection in clause B of 39B. 39 is concerned, where an instrument has been sent to the Deputy Commissioner under subsection 2 of section 37, DC shall, when he has dealt with it as provided with this section, return it to the impounding officer. Suppose the document has been sent by a public authority after impounding, then after dealing with it, he has to send it back to the impounding officer. As far as court is concerned, he will have to return it to the court. I'll take that provision a little later. Then 40, if you come,
by accident.
40, if you come, instruments unduly stamped by accident. Here, if something has gone wrong, a time limit of 1 year is prescribed. That you can read it in this provision. That is the intendment of it. The time limit having been fixed therein, everybody has to follow it. That is the importance. Then, as far as 41 is concerned, instruments, endorsement of instruments on which duty has been paid under section 34, 39, 40. 33 is impounding. 34 is again sending it to the Deputy Commissioner after either receiving the penalty or otherwise, and thereafter its examination by under 39 and so on. So then the authority of the Deputy Commissioner is stated under Section 41, whereby after discharging his duties as enumerated in 34, 39 and 40, the person admitting such instrument in evidence or the Deputy Commissioner as the case may be shall certify by endorsement thereon that the proper duty or as the case may be, the proper duty and penalty have been levied in respect thereof and the name and residence of the person paying them. Then subsection 2, every instrument so endorsed shall thereupon be admissible in evidence. Suppose it is not an impounded document, then it is admissible in evidence. Suppose it is an impounded document, upon payment of duty or penalty or examination, it is being cleared by the authority, then every instrument so endorsed shall thereupon be admissible in evidence and may be registered and acted upon and authenticated as if it had been duly stamped. Then there is a proviso which says, no instrument which has been admitted in evidence upon payment of duty and penalty under Section 34 shall be so delivered before expiration of 1 month from the date of such impounding. Suppose somebody wants to cheat the government. The moment the document is impounded, he wants to take the document back, makes an application, return the document back to me. Then there is a injunction on the authority which impounded it not to return the document within 1 month from the date of impounding. Or if the Deputy Commissioner has certified that its further detention is necessary and has not been cancelled and has not cancelled such certificate. That is an injunction against the impounding authority as well as the Deputy Commissioner both. That is 1 month they will have to hold the document. Then subsection B, proviso B, nothing in this section shall affect Order 13, Rule 9 of first schedule to the Code of Civil Procedure, that wherein the impounding, return of documents, everything has been dealt with. Then 42 provides for prosecution against the offences punishable on account of the evasion of stamp duty and other things. There, with regard to bar of with regard to no bar being for prosecution, despite paying the penalty and other things have been stipulated, we need not have to bother much about it. I'll come to it a little later when it becomes necessary. Then 43, you will see persons paying duty or penalty may recover the same in certain cases. Suppose there is an agreement between the parties that so and so shall pay but does not pay, and the other person produces the document before the court, pays the duty and penalty, then in that event, this section authorizes the person who paid the duty and penalty to recover it from the person who is liable to pay in terms of the provisions made under the Act, casting liability on the person who executed, who gets the benefit of the document is concerned. Then, suppose it is by the court can also, subsection 3 of 43.3 says that the court can include the same in the memorandum of costs also. That is what is contemplated therein. Then the power of revenue authority to refund penalty or excess of duty in certain cases is provided in section 44, where it says, where any penalty is levied under section 34 or section 39, the chief controlling revenue authority may, upon application in writing within 1 year from the date of payment, refund such penalty wholly or in part. The interest of the persons has been taken note of by the provisions available under the Act. Then 40, you will find non-liability for loss of instrument sent under section 37. Suppose a court sends the document, authenticated document in case of penalty, or original in case of non-payment of penalty. There, an amount of a sort of immunity is granted by this provision, that is 45, which says, if any instrument sent to the Deputy Commissioner under subsection 2 of section 37 is lost, destroyed or damaged during transmission, the person sending the same shall not be liable for such loss, destruction or damage. It is an immunity against prosecution or claim for damages, etc. that is provided therein. Then when an instrument is about to be sent, the person in whose possession it came into the hands of the person impounding the same may require a copy thereof to be made at the expense of such first mentioned person and authenticated by the person impounding such instrument. Before sending it, please give me a authenticated copy. A request can be made and it can be allowed. Then 45 is a special provision as far as registering authority is concerned. That is under violation of stamps as far at the time of registration. This has a bearing. Here, this authority has no power to impound. He can only keep the document pending registration. Once he keeps the document pending registration, what is the procedure to be followed is enumerated therein. And the power of the Deputy Commissioner, everything is stated therein. What I wanted to say here is that there is no power of impounding a document in excess while considering it under Section 45A is concerned. It only enables the registering authority to pend the transaction and not to finalize it unless it gets cleared from the Deputy Commissioner is concerned. Then here on, we will move to Section 58. Revision of certain decisions of courts. Even the decision of court can be revised regarding sufficiency of stamps, only limited to that aspect of the matter regarding sufficiency of terms. When any court in exercise of its civil or revenue jurisdiction or any criminal court in exercise of the power under Chapter 12 or Chapter 36 of CRPC makes any order admitting any instrument in evidence as duly stamped or as not requiring a stamp. Suppose it was not objected to, it is already marked, the decision being not reopenable therein, then such instruments come in here as not duly, as not requiring stamp, or upon payment of duty and penalty under subsection 34. Suppose less amount has been collected, calculation was wrong, everything falls herein. The court to which appeals lie from or references are made by such first mentioned court, that is an appellate court or a revision court, may of its own motion, that is the first appellate court or the revision court, whichever is the first one, may on its own motion or on the application of the Deputy Commissioner take such order into consideration, that is the document which was admitted without objection and not being reopenable by the once it is admitted, or an order passed leaving duty and penalty, and all such things can be reopened herein. Then subsection 2, if such court after such consideration is of the opinion that such instrument should not have been admitted in evidence without the payment of duty and penalty under Section 34, or without the payment of higher duty and penalty than those paid, it may record a declaration to that effect and determine the amount of duty with which such instrument is chargeable, and may require any person in whose possession or power such instrument then is to produce the same, and may impound the same when produced. Suppose the document has been returned after disposal of the suit, or has been withdrawn surreptitiously, or whatever it is, before the appeal time is over or during the pendency of the appeal, then the court can, appellate court or the revision court, can call upon the person in whose possession the document is there and impound the same, and thereafter deal with the document in the same manner as was dealt by the original court. That is, referring the document to the Deputy Commissioner for examination and further action is concerned. So these are the provisions with which we will be considering, and how they have been dealt with by the courts can be seen from a few judgments which I will be sharing on the screen. The first one of it is Gangapa versus Fakirappa. First one, 2019, 3 SCC 788. No, next 2019, 3 SCC 788. With 9 other 19th. 2019, 3 SCC 788. The first is the third, yeah. Here it was a suit for specific requirements. The admission of document was objected to. The trial court found the document to be not properly or duly stamped. It levied penalty at the rate of 2 times of the deficit amount, which was made good by the plaintiff. And that order was challenged before the High Court by the defendant, saying that it ought to be 10 times, the court not being empowered to exercise any discretionary power. And that writ petition was allowed by the High Court, and the matter was carried in appeal or specially before the Supreme Court by the plaintiff. Para 7 is the question for consideration. First, title. Title of the parties, you may kindly note it, 2019 3 SEC 788, Gangapa versus Fakirappa. Para 7 is the question which arose for consideration. Trial court imposed only double the penalty, but double the amount as penalty. High Court said, no, you ought to have imposed 10 times the penalty because you don't have any discretion. While saying so, the High Court relied upon a division bench judgment of the Karnataka High Court, which is quite comprehensive enough. That is in the case of Digambar Varti, which I'll refer to a little later. And applying the principles laid down therein, the division and the learned single judge being bound by the division bench judgment held that the order of the trial court is wrong. Then question 7, para 7 shows the question which arose for consideration before the Supreme Court when the matter is carried on by the plaintiff before the Supreme Court. The issue which needs to be answered in the present case is as to whether the trial court which had admitted the agreements to sell in evidence could have exercised its discretion in imposing penalty at the rate of 2 times of deficit amount of stamp duty, or it was obligatory for the trial court to impose the penalty at the rate of 10 times. Then, considering the rival contentions at para 18, it says, Honorable Supreme Court says, para 18, the above view of the Karnataka High Court, that is, in the case of para 17, if you were to see para 17, please go to para 17. It refers to the division bench judgment of Karnataka High Court in the case of Digambar Varti versus Bangalore Urban District, reported in 2000, ILR 2013, Karnataka 2099. It is extracted therein. Then, after extracting it, para 18, this is the ratio of law laid down by the Supreme Court. The above view of the Karnataka High Court, that there is no discretion vested with the authority impounding the document in the matter of collecting duty under Section 33 is correct. The division bench judgment is approved here. The word used in the said proviso is shall, quote and unquote. Section 33 and 34 clearly indicate that the penalty imposed has to be 10 times. The interpretation, the division bench of the Karnataka High Court in Digambar Varti has rightly interpreted the provisions of Section 33 and 34 of the Act. We thus are of the view that the High Court in the impugned judgment did not commit any error in relying on the judgment of the division bench in Digambar Varti. We thus have to uphold the view expressed in the impugned judgment. The High Court view was upheld. Virtually, the appeal was to be dismissed. However, taking into consideration that the litigation has been pending for a long time and all, probably in exercise of the powers under Article 142 of the Constitution by the Supreme Court, in para 20, if you were to see, since they were villagers, agriculturists and all, probably in exercise of their powers, in the middle you will find, in the facts of the present case, we are of view that the ends of justice will be served in closing the matter by confirming the order of deficit stamp duty with double the penalty as imposed by the trial court, which shall obviate the proceeding of approaching the Deputy Commissioner for reduction in penalty under Section 38, which in the facts of the present case and for the reasons noted by the trial court was a relevant consideration for refund or reduction of the penalty. Then para 21, again they emphasize saying that last 3 lines of that paragraph. We in the facts of the present case close the proceeding regarding penalty on the agreement to sell and so on. So what has been said is law laid down by the Karnataka High Court in Digambar Varti is the correct law that is required to be followed. As far as impounding by the court is concerned, the Section 33 being enabling provision, under 34 it cannot do anything other than imposing 10 times the penalty is concerned. That view has been upheld. Then the next judgment which I wanted to draw the attention of the viewers and listeners is reported in the case of Sitaram Bhama versus Ram Avatar Bhama, 2018, 15 SCC 130. Here it was a suit for partition and separate possession between 2 brothers. A document which was not duly stamped and registered, and it failed to be a memorandum of partition was produced. That was objected to by the defendant, and the objection was upheld after hearing the parties. The matter having reached the Supreme Court, the question for consideration you can find in para 10. The only question which needs to be considered in the present case is as to whether document dated 9/9/94 could have been accepted by the trial court in evidence, or the trial court has rightly held the said document inadmissible. It was in the context of the document being non-registered, the matter was carried to the Supreme Court because there it was not a memorandum of partition but a partition as such. Then that was dealt with. Little later you will find about 3-4 lines down below that, after the date 9/9/94, you will find there were more than one reasons due to which we are of the view that document dated 9/9/94 was not mere memorandum of family settlement, rather a family settlement itself. The document itself is a family settlement and not a memorandum of past transaction, that is recording a past event in the form of a memorandum. Then last but 4 lines of that paragraph, you will find in any view of the matter, there is a requirement of rights of other heirs of the properties. Hence, the courts below are right in their conclusion that there being relinquishment documented 9/9/84 was compulsorily registrable under Section 17 of the Registration Act. I am referring this document for this judgment for 2 purposes. That is, in vis-a-vis the memorandum of partition and the partition, as well as the collateral purpose which is sought to be introduced, which you will find in para 12. Sorry, the finding as far as this is concerned, you will find the finding in respect of the question at para 10. You will find the answer at para 12. We are thus in full agreement with the view taken by the trial court as well as the High Court that the endorsement dated 9/9/84 was compulsorily registrable. The document also being not stamped could not have been accepted in evidence, and the order of the trial court allowing the application under Order 13, Rule 3 of CPC and the reasons given by the trial court in allowing the application of the defendant holding the document is inadmissible cannot be faulted. So that question was answered against the appellant therein. Then the next paragraph you will find an interesting aspect which we will have to deal with. There is only one aspect of the matter which needs consideration. That is whether the document dated 9/9/94, which was inadmissible in evidence, could have been used for any collateral purpose, not for proving the right of the party, but for collateral purpose. Then they say, in a suit for partition, an unregistered document can be relied upon for a collateral purpose, that is, severancy of title, nature of possession of various shares, but not for, please mark these words, but not for the primary purpose, that is, division of joint properties by metes and bounds. Further, further, unstamped instrument is not admissible in evidence even for collateral purpose until the same is impounded. So it has to be first impounded, duty and penalty has to be determined, then only it is admissible evidence, not for collateral purpose. That view, kindly go I'll take you to paragraph 15, the finding. Vis-a-vis this secondary question. Following the law laid down by this court in the above case, we are of the opinion that the document dated 9/9/94 may be admissible in evidence for collateral purpose, provided, this is where the issue comes, provided the appellant gets the document impounded to pay the stamp duty together with penalty as has been directed in the above case. That is the one which has been extracted in the paragraph above. Then last but two lines in the judgment at paragraph 16. This appeal is partly allowed, holding that deed dated so-and-so is admissible in evidence for collateral purpose, subject to payment of stamp duty and penalty. So even for collateral purpose, it is not allowable, is the one which I wanted to emphasize here. The next judgment, I would take you to that of Black Pearl Hotels, where the High Court, learned judge of the High Court, instead of examining the aspects, delegated the matter to the Registrar Judicial. That was carried or challenged before the Supreme Court. Then it was submitted. Then the question for consideration, you will find the argument is, you can find in para 6. Fourth line. Alternatively, you will find in the middle. Alternatively, it is argued that whether it is a lease or a license was required to be decided by the learned judge, and the said judicial determination could not have been delegated to the registrar of the court. It is urged by her that the court can only require the registrar for determining whether the document deserves to be impounded or not, only after alluding to the nature of the document under section 33 and 37 of the Act. This is the contention advanced. Then after considering the rival contentions and after noticing a judgment of prior judgment of the Supreme Court, which I'll refer to a little later, as well as the relevant provisions of the Act, come to paragraph 15, about 15 lines from the beginning. In the middle, you will find it says, what is delegated under the proviso B? What is delegated? What is delegated under paragraph 15 only? From fourth line from the in the screen, you can see what is delegated under proviso B of clause of subsection 2 of section 33 is only to determine the instrument for the purpose of determining as to whether the instrument is duly stamped or not, and not for impounding the same. That is, registrar cannot impound it; he can only examine for the limited purpose. Then, para 16, you will find it is evincible from the impugned order that the learned judge has left both aspects, that is, impounding and determination. That is, determination of the nature and character of the document and impounding of the same to the registrar. Therefore, the sentimental question that arises for consideration is whether the learned judge, for the purpose of determining the character of the instrument, could have delegated authority to the registrar. A judicial proceeding has to be done in a judicial manner. The duty of determining of an instrument or to explicate, to determine when there is a contest, a particular document to be of a specific nature. The adjudication has to be done by the judge after hearing the counsel for the parties. It is a part of the judicial function and hence the same cannot be delegated. Be it noted that the High Court rules in certain High Courts, the computation is done by authorities in the registry with regard to the court fee, but that is also a subject matter to be challenged subject matter to challenge before the court when the applicability of a particular provision of the Court Fees Act is concerned. Thus analyzed, we are inclined to think that the authority is not empowered to determine the nature and character of the document. He may at best send a report to the court expressing his views on a document which is subject to final determination by the court. That is explaining the proviso B under section 33(2) is concerned. Then you will find another judgment of the Supreme Court in 2015, 16 SCC 787. 2015, 16 SCC 787. Yalapu Uma versus Buddha Jagadishwar. Here, the questions, here it is a suit for partition. Again, the objection with regard to document being inadmissible in evidence vis-a-vis the Section 17 of the Registration Act and the Stamp Act over the subject matter of consideration. That there was also a memorandum of partition and that was objected to. The questions which arose before the court have been enlisted in para 11. 11.1 you can see whether the courts below were right in holding that exhibits B21 and exhibit B22 are not admissible in evidence as they are compulsorily registerable documents. Then second one is whether exhibits so and so are admissible in evidence for collateral purpose. Both have been answered against, which you can find in para 15, last part. Last 3 lines of para 15. We are of the considered opinion that exhibit B21 and B22 are not admissible in evidence for the purpose of proving primary purpose of partition. Then 16. Then the next question for consideration is whether these can be used for any collateral purpose. That has been discussed and held about 4-5 lines below. In a suit for partition, an unregistered document can be relied upon for collateral purpose, that is severancy of title, nature of possession of various shares, but not for any primary purpose, that is division of joint family properties by metes and bounds. An unstamped instrument is not admissible in evidence even for collateral purpose until the same is impounded. Hence, if the appellant defendant wants to mark these documents for collateral purpose, it is open to them to pay stamp duty together with penalty and get the document impounded, and the trial court is at liberty to mark exhibits B21, B22 for collateral purpose subject to proof and relevancy. That is the finding given. Then I'll take you to a judgment of the Supreme Court reported in the case of Om Prakash versus Lakshmi Narayan, 2014, 1 SCC 4618. Here, what the court is required to do is see the instrument and not the averments in the pleadings. Suppose the pleadings are twisted or put forth in a manner different from the one stated in the instrument. While exercising the powers under section 33 and 34, what the court has to see is the one written in the document and not otherwise. I'll take you to para 10. Para 10 shows, in view of the rival submissions, para 10, in view of the rival submissions, the question which calls for our determination is as to whether the admissibility of a document produced by the party would depend on the recitals in the document or the plea of the adversary in the suit, and whether the document in question is a conveyance as defined under the Act and is duly stamped. There, the pleading was different from the instrument, the recitals in the instrument. The finding, you will see it just above para 19, referring to an earlier judgment of the High Court, which view was endorsed or agreed with by the Supreme Court. The quoted portion there in para 9, it would be tried to say that if in a document certain recitals are made, then the court would decide the admissibility of the document on the strength of such recitals and not otherwise. In a given case, if there is an absolute unregistered sale deed and the party said the same is not required to be registered, then we do not think that the court would be entitled to admit the document because simply the parties say so. The jurisdiction of the court flows from sections 33, 35, and 38 of the Stamp Act, and the court has to decide the question of admissibility. With all humility at our command, we overrule the judgment in so and so. That view was endorsed by the Supreme Court. In the next line, we respectfully agree with the conclusion of the High Court in this regard, meaning thereby the instrument has to be read, the recital of the instrument has to be read, and not what has been stated in the pleadings of the parties. Then the judgment of the Supreme Court in the case of SMST Estates, reported in 2011, 14 SCC, page 66. All these judgments I will be sharing with you. You can access Mr. Basuraj. He will have a compilation of all these things. He will make available to all those who are in requirement of it.
Yes, sir. Yes, sir. I shall do that.
Okay. Kindly move to para 9. The questions which arose for consideration. There are 3 questions. I'll only refer to the second question, para 9.2. Whether this is in the context of an arbitration agreement which was unregistered and whether it is required to be duly stamped. This power was this examination was in the context of the invoking of jurisdiction of the High Court or the Chief Justice or the delegate of the Chief Justice under section 11 of the Arbitration and Conciliation Act. Suppose the document is unduly stamped, is not duly stamped, and if it is compulsory registrable, is not registered, whether the Chief Justice or the delegate of the learned Chief Justice is required to examine the document vis-a-vis the provisions of the Stamp Act and render a finding was the subject matter of consideration. That can be found in para 9.2, whether an arbitration agreement in an unregistered instrument which is not duly stamped is valid and enforceable. That question has been considered in para 21. Therefore, when a lease deed or any other instrument is relied upon as contending the arbitration agreement, the court should consider at the outset whether an objection in that behalf is raised or not. The court should consider at the outset whether an objection is raised or not, meaning thereby it is the duty of the court whether and not that of the objector before it, whether the document is properly stamped. If it comes to the conclusion that it is not properly stamped, it should be impounded and dealt with in the manner specified in section 38 of the Act. The court cannot act upon such a document or the arbitration clause therein. But if the deficit duty and penalty is paid in the matter set out in section 35 or section 40 of the Act, the document can be acted upon or admitted in evidence. We may therefore sum up, this is how the summary is drawn. We may therefore sum up the procedure to be adopted where the arbitration clause is contained in a document which is not registered but compulsorily registrable and which is not duly stamped. Then they enumerate in 22.1 to 22.4 the procedure. That is 22.1. The court should, before admitting any document into evidence or acting upon such document, not necessarily admitting into evidence, but while acting upon such document to find out whether there is an arbitration clause or not also, whether the instrument or document is duly stamped and whether it is an instrument which is compulsorily registrable. That is the first consideration. Then second one, if the document is found to be not duly stamped, section 35 of the Stamp Act bars, there it is the it is Assam Stamp Act, that's why it is section 35. Here, as far as we are concerned, it is 34. Bars the said document being acted upon. Consequently, even the arbitration clause therein cannot be acted upon. The court should then proceed to impound the document under section 33 of the Stamp Act and follow the procedure under section 35 and 38 of the Stamp Act. Suppose it escapes the attention of the learned Chief Justice or his delegate under section 11. Even the arbitrator, if the question is raised, or if the arbitrator comes to know that it has not been duly stamped, he has to impound the document, then follow the procedure as mandated under the provisions of the relevant provisions of the Act, which I have adverted to earlier. Then 22(3), if the document is found to be duly stamped, or if the deficient stamp duty and penalty is paid, either before the court or before the collector, as contemplated in Section 35 or 40 of the Act, and the defect with reference to this deficient stamp duty is cured, the court may treat the document as duly stamped. Therefore, once the document is found to be duly stamped, the court shall proceed to consider whether the document is compulsorily registrable. If the document is found to be not compulsorily registrable, the court can act upon the arbitration agreement without any impediment. This is in the context of Arbitration Act. These principles have been enumerated. However, the same apply to the civil litigation as well. Then you will come across another judgment, which is nothing but reiteration of what I said. That is, the instrument has to be the recitals in the instrument and not the pleadings of the parties. You will find another judgment of the Supreme Court in 2009, 2 SCC 532, Avinash Kumar Chauhan versus Vijay Krishna Mishra. The relevant paragraphs are 21 to 23. You may kindly read for yourself. I will not take your time because it is same principle which I read out earlier. Then the earliest of the judgments you will find in 2001, 4 SCC 197. That is Chilakuri Gangulappa versus Revenue Divisional Officer. This arose from the Stamp Act of Andhra Pradesh. I'll only take you to the head note. Relevant paragraphs are 12 to paragraph is 11 and 12, but head note itself is sufficient. Only a relevant portion of the head note, I'll read it. Just 4 lines from the bottom. Documents need to be, or I'll read the head note. This is court, when faced with an instrument, has power under 38 read with 33 to admit the document in evidence upon payment of duty with penalty and to send an authenticated copy to the collector along with the amount realized. Documents need to be impounded and sent to the collector only if party concerned refuses to pay. Suppose the party pays this stamp duty, then authenticated copy is only required to be sent so that the proceedings of the case doesn't get unnecessarily hampered. Then, as far as this Section 45A is concerned, which is in parameteria with Section 47A of Tamil Nadu Stamp Act is Stamp Act, there is judgment of the Supreme Court in the case of Government of Tamil Nadu versus Parkview Enterprises, reported in 2001, Volume 1 SEC 742. It is a parameteria provision as far as 45A of our Act is concerned. This becomes easily available to all of you. Kindly go through it. Then there is one of the earliest judgments of the Supreme Court vis-a-vis this Section 31 and 32 are concerned. Now I'll come to Section 31 and 32. There is a window open to everybody who has entered into a transaction and the transaction has been recorded on insufficiently stamped document or is about to be recorded. In such an event, what is to be done can be seen in Section 31. 31 of the Act. This is a provision which can be made use of by all those people who are vigilant enough before the document is produced or tendered in evidence. 31, adjudication as to stamps. It's a provision which is beneficial, which may not be in favor of the state, but in favor of the person who wants to, who is liable to pay the stamp duty is concerned. Adjudication as to proper stamps, where any instrument, whether executed or not, even in the executory stage also, not already executed or not, and whether previously stamped or not, is brought to the Deputy Commissioner and the person bringing it applies to have the opinion of that officer as to the duty, if any, with which it is chargeable, and pays a fee of rupees 100. The DC shall determine the duty, if any, with which, in his judgment, the instrument is chargeable. That is, merely seeking the opinion of the DC by paying 100 rupees. It may be a document which is already executed or about to be executed also. Then subsection 2 says, here there is no provision for impounding it. It is only a rendering of an opinion is concerned. Then subsection 2, for the purpose, that is for doing what is contemplated 31, the DC may require to be furnished with an abstract of the instrument and also with such affidavit or other evidence as he may deem necessary to prove that all facts and circumstances affecting chargeability of the instrument with duty or the amount of duty with which it is chargeable are fully and truly set forth therein, and may refuse to proceed upon such application until such abstract and evidence have been furnished. Meaning thereby, either you make available a copy of the document which is executed or sought to be executed and seek the opinion. What else can be done? This is the best way to wriggle out of a very bad situation in which a person would be placed. Maybe unknowingly, the document has not been done on the appropriate stamp paper. Instead of paying penalty, which may be even up to the extent of 10 times, avail this opportunity. 31 is, according to me, a very, very useful provision for everybody who is liable to pay the duty and or penalty, as the case may be, to avoid the unnecessary liability is concerned. Just pay 100 rupees and be done with it. I have not come across many people making use of this provision. This is a very beneficial provision, according to me, should be always put into action by everybody concerned. And on that, you will find this judgment of the Supreme Court reported in Raja Muhammad. That is the next judgment which I will be referring to. That is Raja Muhammad. Sorry, Governor of UP versus Raja Muhammad. Reported in AR 1961 SC 787, as well as the larger bench judgment or 5 judges bench judgment, Constitution bench judgment reported in AR 1963 SC 1307. It was a judgment rendered in exercise of the jurisdiction under section 32 of Article 32 of the Constitution. There, the property was situated in West Bengal. It was registered there, sought to be made use of in Uttar Pradesh. Then the authority at Uttar Pradesh raised objection with regard to the admissibility of the document. He wanted to levy the penalty. The provisions of the acts, which are pari materia with our provision, have been discussed in length. Kindly go through those 2 judgments. It's very beneficial to everyone. Then coming to 32, there is a hitch. 32. I had an interesting case to deal with in Gulbarga. The document had been insufficiently stamped. It was sought to be produced along with the plaint. The person, the advocate, must have advised that you pay the difference of stamp duty before the court itself. So stamp duty was purchased, produced along with the document accompanying the plaint. See, the document is required to be drawn on the requisite stamp paper, or it has to be impounded and validated in the manner provided under the Act. You cannot supply the deficit stamp duty separately. Suppose 100 rupees is the stamp duty payable in respect of an instrument, and 50 has only been paid, and realizing that another 50 has to be paid, it can be paid before the authority before which it is to be paid. It can't be made good before the court by producing the deficit stamp paper of rupees 50. Such a decision came before me.
Citation, sir?
Citation 2017 SCC Online Karnataka.
Oh, very important judgment.
The title is Dandamudi Ramesh versus Sharanappa. Dandamudi Ramesh versus Sharanappa. 2017 SEC Online Karnataka 3709. It is reported in almost every journal. I am referring to SEC Online so that it will be easily available. 3709. It is in there. ILR cases, KCR, ICC, everything it is there. Equivalent citations are there. I held it is not permissible. It has to suffer. It has been rightly impounded, and now the process has to be set into motion. That's why the plea was not accepted, and party was directed to avail the remedy in accordance with the provisions under the Stamp Act. 32, you will find certificate by the Deputy Commissioner. When he is giving a certificate, when an instrument brought to the Deputy Commissioner under Section 31, in his opinion, one of a description chargeable with duty, that means executed document, the Deputy Commissioner determines that it is already fully paid, or the duty determined by the Deputy Commissioner under Section 31, or such sum with the duty already paid in respect of the instrument is equal to the duty so determined has been paid. That is in respect of an executed document, not in respect of a document to be executed. The Deputy Commissioner said then he has to certify, and once he certifies it, that shall be good for all the proceedings is what is stated in the next following provisions. When such instrument is, in his opinion, not chargeable with duty, shall certify in the manner aforesaid that such instrument is not chargeable, subject to such orders made under subsection under Chapter 6. Any instrument upon which an endorsement has been made under the section shall be deemed to be duly stamped or not chargeable with duty, as the case may be, and if chargeable with duty, shall be receivable in evidence or otherwise, and may be acted upon and registered as if it has been originally duly stamped. However, provided that nothing in this section shall authorize Deputy Commissioner to endorse, there is a clock there, time limits have been set in. You see there, A, any instrument executed, it is in respect of instruments which are already executed, not to be executed, that is what 31 contemplated. Any instrument executed or first executed in India has been brought to him, that is Deputy Commissioner, after expiration of 1 month from the date of its execution or first execution, as the case may be. Means a foreign document brought into India, then produced before the Deputy Commissioner. It should not be after one month from the date of its execution. No. This is B is concerned executed in India and brought before the Deputy Commissioner. B is concerned executed outside India, then 3 months. If it is a foreign document, it is 3 months. If it is an Indian document, it is 1 month. That is the time limits that has been prescribed. So I would suggest that everyone who has this dilemma, whether the document to be executed, what is the stamp duty payable, please seek the opinion of the Deputy Commissioner under the provisions under Section 31 of the Act. As far as the other provisions are concerned, there is no escape. Then when a document is produced before a court, whether the court should wait till the document is made use of for evidence, or whether it can, the moment it notices that it has suffered stamp duty or not, whether it can take action, was the subject matter of discussion and decision in a case reported in ILR 2013, Karnataka 368. There was difference of opinion, or sought to be made out that there is a difference of opinion. Matter was referred to the division bench. Para 2, that is in the case of Miss Sandra Leslie versus Miss Ganavati. Para 2. ILR 2, that is ILR 2013. Kotilva. Ide noduppa. National ide. Sandra Leslie ilva. Ide nodu. 12 alli. Year ಹಾಕಿದಾರಾ? ILR. ILR 2013. 368. Vasaraj, make a correction. It has been shown as AR in the list which I have given to you.
I shall do that, sir. I shall.
Yes. Para 2. The question that arose before the learned judge in writ petition is in respect of, quote unquote, impounding an insufficiently stamped document. According to the defendant, in view of Section 33 of the Act, the moment an insufficiently stamped document is produced before the court has to impound the same. This is the contention of the defendant. It was contended by the plaintiff that the question of impounding of the insufficiently stamped document would come into play only when a party is intending to rely upon such a document tenders in his evidence. That is, when he sought to make use of the document in the evidence, then only it can be done and not otherwise. That is the discussion. That is the question. Now turn to para 11. Para 11. Ilva. ILR 2013. Sikilva. ಹೌದಾ ಸರಿ ಇದೆ ತಗೋ ಆಯ್ತು ಇಟ್ಸಕೋ ಇಲ್ತು ಪಾರ್ಟಿಸ್ ನೇಮ್ ನೋಡಿ ಸಿಗತ್ತಲ್ಲ (2013-368). Para 11 is the discussion. Show the title first. Yes. Division bench judgment. Now come to para 11.
We got it.
There are two different circumstances under the Stamp Act. There are two different circumstances under the Stamp Act for impounding a document. One, the court has the power to impound the document moment it appears to the court that such instrument is not duly stamped. And two, or that is either way, or to wait till such instrument is tendered in the evidence. So these are the two circumstances for impounding as far as the court is concerned. A combined reading of sections 33 and 34 clearly reveal that a discretion is granted to the court either to impound the document under section 33 before the same is tendered in evidence, and if a document is not impounded under section 33, the court is bound to impound the document when the same is tendered in evidence under section 34. In other words, the court cannot say that it will wait till the document is tendered in evidence. Then coming to para 12. Court cannot say that it would impound the document only when document is tendered in evidence for marking. There may be instances where duty and penalty payable may be very high and the party may not choose to rely upon such insufficiently stamped document in order to avoid stamp duty and penalty. In such circumstances, it would result in loss of revenue to the exchequer. The power of impounding a document is to collect the stamp duty and penalty whenever there is an escape of duty. Therefore, when it is brought to the notice of the court that the document is insufficiently stamped, the court exercising its power under section 33 of the Act has to pass an order at the first instance for impounding the document. Though there is a discretion vested in the court to exercise the powers under section 33 or 34 of the Act, no court can hold that it would wait till the document is tendered in evidence. In such circumstances, there may be chances of loss of revenue to the exchequer, which should not be allowed. Then the finding is para 30 to the question which I read out. In these circumstances, we answer the reference holding that under Section 33 of the Act, the moment insufficiently stamped instrument comes to the notice of the court, the same has to be imported in accordance with Section 33, whether the same would be relied upon by the party under Section 34 or not. That is how the writ petition was disposed of. So my submissions by way of summary is this chapter 4 is the heart and soul as far as the revenue of the state is concerned. And in order to safeguard its revenue, it has entrusted its duty of collecting the duty and penalty to the persons authorized by law or persons having authority to record evidence by consent of the parties or to public authorities. These are the three agencies which have been entrusted with the responsibility of safeguarding the revenue of the state is concerned. Revenue is very much essential for any state to perform its obligations entrusted by the Constitution on the state is concerned. There are a number of welfare activities which it has to cater to, and for that revenue is a big component. And as all of you know, I am given to understand this is the third largest revenue as far as state is concerned. Now after this GST has come, these states have been made to virtually stand with folded hands before the central government, release our funds, release our funds. And they say that you borrow, but we will not do it. This is what has happened yesterday. I really do not know how they can say, instead of they borrowing, they ask the states to borrow. Now, there are this excise, stamp duty, and this what is being levied on this fuel. These are the three main things which have remained with the state government. The rest of it, nobody has control. We earn and we cater to the needs of other states which are not developed as much. I am given to understand 4 states in India are taking care of the entire nation. The revenue collected, the taxes collected by Maharashtra, Tamil Nadu, Karnataka, and Andhra Pradesh. These are the 4 states which are virtually taking care of the rest of the country. These are the places where a lot of revenue is being collected in the form of GST, and that is now being shared proportionately to every state, because it is one nation and one tax theory that has come into existence. Now, be it as it is, they are also our brothers and sisters. We can't disown them. But however, whatever is due to the state is required to be paid. It is all politics. Let us not go into that. There are people who will take care of it. But as far as the Section 3 being the charging section, the duty to see that the charged revenue or chargeable revenue comes to the state treasury is concerned has been entrusted to, very wisely entrusted to these 3 authorities, that is persons authorized by law. One means public authorities again, are the courts concerned. Then the other category is those who are authorized to record evidence, even by consent of the parties, meaning thereby probably the arbitration, mediation, or all such things, ADR methods, they come into being. Those who follow the summary procedure of recording evidence under Section 33 of the Land Revenue Act is concerned, which provides for recording summary proceedings are concerned. They are supposed to record the summary of evidence. And once that comes into picture, whether it is in the form of detailed inquiry or otherwise, then any document which is produced before such authorities are liable to be examined for the purpose of finding out whether they have suffered proper stamp duty or not. If not to stall the proceedings, the party liable to pay the duty can be asked to pay the deficit stamp duty and 10 times the penalty. But however, that 10 times penalty paid is only a temporary measure so that the proceedings can continue. It doesn't get stuck. If penalty is not paid, then what happens is the original document itself has to be sent to the Deputy Commissioner. Deputy Commissioner may take his own time to decide. Maybe years together, the matter may be pending because they are not exclusive dealing with these matters only. They have various other duties also. They may not find time. That's why the proceedings before the court or the public authority may get delayed. In order to shorten that aspect of the matter, the court or the public authority has been empowered to levy the duty. Then whatever duty collected and penalty levied, along with an authenticated copy, is required to be sent to the Deputy Commissioner. Ultimately, it is the Deputy Commissioner who can decide what is the duty payable and what is the penalty leviable. Deputy Commissioner need not levy 10 times the penalty. He has the discretion. That has been discussed at great length in Digambara, to which I had also made a small contribution. How it is, I am not a party to the judgment. I will not make any further revelation. I will stop there itself. Then there is a lengthy judgment by His Lordship Justice Kumar, sitting with Justice Pinto in the bench. It is a very well written, well articulated, and very well reasoned judgment, which has been approved by the Supreme Court in that Fakirappa's case, which was the first citation which I read out today. Have a reading of that Digambara. According to me, it is nothing but a Bible as far as Karnataka Stamp Act is concerned. It runs to about, typed pages are concerned, it was about 300 pages. Printed pages, it is less than that. You will find one entire volume of, entire part of ILR being spent on that. But however, a lot of work was done, and it has found its ready acceptance, ready ratification by the Supreme Court in that Fakirappa case is concerned. Once my friends who are appearing before the courts or public authorities wants to have have further information on this aspect of the matter, they can go through all the judgments which I have referred to, and also the Digambara judgment, because it has been put it in a very great length. If I keep referring to that judgment, naturally I'll be spending much of your time, which I do not want to in the weekend. So I would suggest that please make use of, as far as lawyers are concerned, their interest is to protect the client's interest. For them, I would suggest, please make use of Section 31. Obtain the opinion of the Deputy Commissioner. Pay 100 rupees only. Once the opinion is there, then you can decide whether there is any element of deficit stamp duty payable. If it is to be paid, whether instead of paying the deficit stamp duty, produce the document before the court and invite the consequences of 10 times the penalty. Instead, what I would suggest is, if it is unknowingly a document which has not been duly stamped for various reasons, maybe lack of knowledge or somebody misleading the person who is liable to pay the stamp duty not being paid, then in that event, take the document to the Deputy Commissioner first. Let him decide. That shortens the process itself. Once he certifies, then that certificate holds good before a court, exercising the power under 33, 34, or 37, 38 is concerned.
And the harassment of undervaluation also would not be there.
Everything gets solved.
That's the biggest problem many of us
Yes.
face. Undervaluation.
31 is a weapon which everybody should make use of it. Once the opinion of the Deputy Commissioner is there, that endorsement holds good for everybody, everywhere. So I would suggest, please make use of these provisions. And before producing documents, spend some time to find out for yourself whether the document or the instrument has suffered the requisite stamp duty or not. If it has not suffered, producing before the court, production itself is closing of the chapter. It need not be acted upon. Need not be brought to the notice of the court. The court has, as far as SMST estate is concerned, it is the duty of the court. Just like Section 3 of the Limitation Act, it is the duty of the court to find out whether the lease is within the period of limitation or not. Opposite party need not have to raise it. 33 mandates the court or the public authority to examine whether the document which is brought before it has suffered the requisite stamp duty or not. And once they find it has not been duly stamped, then they are left with no discretion. They are bound to leave it 10 times penalty. And even after that, the proceedings may go on. But again, the authenticated copy will go to the Deputy Commissioner. There will be a supplementary proceeding therein. And the Deputy Commissioner proceedings is not final. It may go to the Chief Revenue Authority is concerned. All that gets obviated once you invoke Section 31. Please invoke these provisions and advise your clients or conduct your proceedings taking aid of all these judgments, which are very handy. The compilation of the judgments I have sent to Mr. Basuraj just prior to the beginning of the webinar. All those friends who wants to have a copy of it, please access him. He will forward the PDF format which I have sent to him. Other than the one which I referred to in the case of that SN Mathur case, wherein the principles have been culled out. This judgment was not readily available to me. I accessed it later. SN Mathur versus Board of Revenue, which is only with regard to the principles of stamp duty is concerned, the act being a fiscal enactment. Rest of that judgment may not be of much use for day-to-day practitioners. The other judgments which I have referred to, particularly this Fakirappa versus Gangapa, is very, very handy. Please make use of this judgment along with that of Digambar Varki. With this, I would conclude my talk. Thank you. Thank you, Basuraj, as well as DakshaLegal for all the care taken in providing the links to all the friends and enabling me to address all of you. Thank you very much.
ಸ್ನೇಹಿತರೆ, ನಾನು ಇದನ್ನ ಹೇಳಲಿಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ ಸಾಹೇಬ್ರದ್ದು ಪರ್ಮಿಷನ್ ತಗೊಂಡು. See, speaking on a popular subject is not a big deal. Everybody is talking about all the big subjects, but picking slightly a dry subject but a dry and extremely useful subject requires commitment. That commitment is to share valuable knowledge on the point so that the advocates can make use of it in their daily practice. I'd heard about Justice ANVG's meticulous preparation, but when I was in Mr. R.V. Vasant Kumar's office, who later became the judge of the Karnataka High Court, I used to watch Mr. ANVG's judgment arguments, as he then was, before the trial court, even before Justice Manjula Chellur, who was a district judge then. But when we got together, myself, Justice ANVG after retirement, and Mr. B.M. Arun, when we together filed a petition, public interest litigation before the Karnataka High Court seeking appointment of judges to the High Court, then I really witnessed the extreme hard work and thorough preparation. And what is more, he even visited the chambers of Sri B.V. Acharya, senior advocate, to brief him. Today, we can see that the sharpness remains intact, and as a matter of fact, it has even multiplied. Therefore, thank you very much, sir. And I must really thank the audience who are extremely disciplined today. Pin drop silence, and it was houseful throughout. And thank you all. I'll request Mr. Jayanna, who is the legal advisor to DakshaLegal Solutions, to offer his vote of thanks. Thereafter, we have almost completed 2 hours continuously. Thereafter, there will be a small question and answer session. Please ask the question only on a question of law, not about the matter pending before the court